Hello ladies and gentlemen, welcome back to this video. In this video I'm going to talk about transfer of property by non-owners. In other words, you're not the owner of the property, you have no title to it, or you have a bad title, but how do you pass property? How does the transfer of property from you to the next person become valid, or how is it addressed in law when you don't actually have legal title? So that's what we're going to cover in this video, and then we'll also talk about aspects of remedies, what remedies are available in law to a buyer and to a seller who's not happy with the performance of the contract. So in this video, we are going to talk about the nemo dat rule or transferring of title and its exceptions. We're going to look at the remedies of a seller who's not been paid but they've supplied the goods, and we're going to look at the rights of a buyer. The nemo dat rule, or when you talk about transfer of title, what are we saying? We're saying as a general rule, a seller cannot transfer a title that is of better quality than what he has obtained. If a seller has obtained a stolen title, he naturally sells or transfers a stolen title. That is the general rule. And this rule was expressed in a maxim that is called the nemo dat rule, meaning no one gives away what they don't possess. This is the meaning of the rule. Nemo dat quod non habet, meaning no one gives what they don't possess. In other words, you don't give away what you don't have. If you have a stolen title, you can only give a stolen title. There are no miracles, and that is the general rule. For example, if a seller has stolen goods, the buyer also receives those stolen goods. They don't receive clearer goods. So the aim of this nemo dat rule was to protect the true owners of goods. That is the rule of the goal of that rule. That the original owners are protected from being defrauded or from other people passing on their titles without their authority. So this nemo dat rule has some exceptions, and these are the ones we're going to focus on. The exceptions, in other words, the incidences whereby someone has a bad title but they'll pass on a good title even if their title was originally bad. And this was established in mainly the case of Bishop Gates Motor Finance Corporation. In that case, Lord Zenin said that the law has two main features it follows. Principles it has tried to achieve mastery over. The first one is the protection of property, and the second one is the protection of commercial transactions. So that where a person who buys something in good faith and for value without notice that it had any problems with it, that kind of person should be able to get a very good title. This is what Lord Den was saying. So this nemo dat rule applies where goods are sold by one person who's not the owner of the goods and he has no authority to sell them with the consent of the owner. In such an instance, the person they sell them to gets a good title. And we're going to see the exceptions or the instances whereby someone has no good title but is able to pass on a good title irrespective of the kind of title he got. There are the exceptions that we're going to cover in the next slides. The first exception we're looking at is what we call estoppel, or to be estopped, or in English to be stopped. Estoppel, or to be stopped, meaning that a seller who holds out or pretends that the person he's presenting forward has authority cannot wake up and pretend that that authority was not there. Let me give you an example. For example, if I am the lecturer, okay, I'm in class, I'm the lecturer, and I have the right to sell maybe past papers. I'm selling past papers. Now, I decide to get your class representative and he sells them on my behalf. I'm also present and I'm watching. I'm not refusing him to sell. The law says that because I am present and watching and I have not stopped him, I have held him out as though he has the right to sell. So I cannot wake up me, the owner, to say that no, the class representative did not have authority to sell, because he did this while I was present, while he had my consent, and I did not stop him from doing so, and I led everyone on to believe that he had the authority to sell. So estoppel works in a way that where the owner of goods is by his conduct, my conduct, me the owner, I'm stopped from denying that the person who's selling, the class representative, did not have authority to sell. That's what estoppel says. So it arises when one is prevented from denying the truth of anything. Here I'll be prevented from denying that I didn't give the class representative authority because I let him sell when I was present, and I didn't stop him, and I led everyone to believe that they had authority. So that kind of sale gives the people who buy from the class representative good title, even if the class representative maybe didn't have authority from me. But because I represented him as though he had authority, I did not stop him, I misrepresented it all. The law says that you guys who buy from the class representative are able to get good title because I'm estopped in law. Me, the seller, I'm estopped in law, the original owner. I'm stopped from denying the authority of the class representative. Exception is in reference to a sale by an agent, usually a mercantile agent. I think you've seen these guys who sell things on behalf of people. For example, they come to your hostels or to your rooms and they're saying, oh, I'm selling these lanterns on behalf of someone. You know, the company has asked me to sell these things, and they're walking around selling things. Those are usually called mercantile agents. And the law says that those guys have authority to sell even if they actually don't have. So you might find that he was not allowed to do any sales, but because he's coming as a representative, the law will allow him, if he's always been a representative of this company, the law will allow him to sell something to you legally and you get a good title, even if on this particular occasion maybe he didn't have authority. Because he's an agent of that company, so the law says that any mercantile agent is entitled to sell good title because he's deemed to have title already originally. That's why you find in this case Fox versus King. Fox entrusted his car to a mercantile agent for sale at a price and said they are not supposed to sell it below that price he gave him. So the agent sold it to a new owner who was innocent, bona fide, below the price he was supposed to sell it at. And then the agent chewed the money. You know, he misappropriated the proceeds, the funds. So the new owner sold the car to someone else called King. Court said that the party who bought from the agent got good title to the car and passed good title to King. Fox was not entitled to cover the car from King because it was sold through a mercantile agent. So even if the agent didn't have the authority to sell it under price, he didn't have that authority. The law says that what he sold was a good title, what the new owners received was a good title because this guy is their agent in law. In other words, you, the buyer, are not required to go and investigate all the time, oh, does this agent have authority today? Or does this guy have authority this time? No. Once he's a mercantile agent or he's their agent, you entrust that he has the authority. And when he sells, even if he doesn't have particular authority for that particular product, in law he's deemed to have sold good title. So sale under special powers of sale. Here we are saying it's an exception because ordinarily these guys don't have power to sell, for example, banks or maybe, you know, brokers, but they are given powers by court to sell property. It's by operation of the law. So the law and maybe the court system permits them to sell even if they don't have power to sell. For example, if you mortgage your property and you default, they can sell it. That's a power to sell that's not authorized. These guys who sell it don't have original authority to sell. But because they are authorized by the law and under the mortgage that you took out, or maybe they're auctioneers or banks are selling mortgage property, those guys have power to sell even if they're not the original owners, even if they don't even have title to those products, but they're entitled to sell because they have operational powers to sell from the law. So that is another exception. That yes, they are not the original owners, but they are going to sell it and they'll have valid sales because they have been given the right to do so by the law. With reference to avoidable title, we all know avoidable title is that kind of title that has not yet been avoided or cancelled. For example, if a minor decides to buy or sell things to someone else, that's avoidable title. In other words, the contract can be cancelled if the party chooses to cancel it, but if they don't choose to cancel it, it stays and stands. So in avoidable title, we are saying that one party can choose to cancel the title because it might be illegal, but if they both agree to keep it legal, then it stays as a legal title. So the law says that someone doesn't have authority to sell. For example, this minor with avoidable title doesn't have authority to sell. But if this title or authority has not been cancelled or avoided, then they pass good title. In other words, when the seller has avoidable title, but the title has not been avoided or cancelled at the time of the sale, the new buyer gets a good title to the goods. if he buys them in good faith and without notice that the person didn't have good title or had a defect in title. An example here is where the goods are acquired fraudulently or by tricking people and they are sold before the owner avoids the contract. The buyer in good faith for value acquires good title. So that is the other exception under the Nemo Dat rule. That if it's a sale under avoidable title, as long as the sale has not been avoided, the transfer of title will be a good title, unless the owners choose to cancel it. Sell by a seller in possession. Here we're looking at an instance where someone has sold goods. For example, I'm the seller selling my scripts to you guys, and then you have paid for them, but I still have the scripts with me. Maybe you still have a little bit of balance to pay me. You've not paid my full price, but I'm still in possession of what I sold to you. The law says that in such an instance, I'm entitled to sell it to someone. I mean, when I sell it to another person, that person gets good title, because they don't have notice of the fact that you had not paid up or I'm not still the owner of the product. Because I'm still in possession and I'm the known seller, the law says that whoever buys from me gets good title. Even if that property had already been bought, they get good title to that property. That's why we say where one sells goods and continues to be in possession of the goods or documents of title and then gives them to someone else who receives them in good faith without notice that there was a previous sale, the second person receives a good title. Sell by a buyer in possession. In this instance, you want to buy a car from me, I sell it to you, and then I give it to you, even if you've not fully paid up the price. But I say, you know what, since you're going to pay me tomorrow, you can take the car today. The law says that the person who buys from you, the buyer who's in possession, they get a good title to that car. Even if I still have a debt, you still have a debt with me. Even if I still kubanja you, the law says that you pass on good title. The person who buys from you, as long as they don't know of our dealings, they get good title. So you are the buyer in possession because you already have the car, you're driving it, but you're not yet the owner because you've not fully paid up my price. I've not yet fully transferred maybe. The law says that if you're in possession, you're the buyer and you're in possession, you even have the documents of title, you're entitled to sell to someone, and whoever you sell the product to, they get good title. So in other words, it's incumbent upon me that the seller not to hand over possession to you until you have finished payment. Otherwise, if I hand over possession to you and you sell it to someone else, the third party gets a very good title, even if you hadn't finished payment with me. So the other exception is a resale by an unpaid seller. A seller has not been paid. The law says that if they've not been paid, they are entitled to resell the product to someone else. And the person to whom they resell gets a good title. So if you've not paid them, it means that there was no consideration that was valid. So it means that they're entitled, when they sell the product to someone else, that person gets a good title, even if they had already sold it to you. But because they've not been paid, they're entitled to sell to someone else. And whoever buys from the seller gets a good title in the products. So now let's talk about the remedies of an unpaid seller. I'm the seller, I have delivered the car to you as we agreed. You're supposed to pay me, you have not paid me. What remedies do I have in law? The law says that I'm deemed to be unpaid if the whole price has not been paid, or where payment is by, for example, a check or an instrument, and that instrument is not honored or the check bounces. So in such an instance, I'm deemed to be an unpaid seller. And I have two rights in law as an unpaid seller. I have a right against the goods, that is, I can come and pursue the goods, but then I also have a right against the buyer. In other words, I can also come and sue and pursue the buyer personally and sue them personally. So let us look at these two rights in detail. We'll start with the rights against the goods, me pursuing the goods. There are three main rights against the goods that I can pursue to get my goods back. The first one is what they call the right of lien, then the stopping in transit, and then right of resale. So we'll talk about the right of lien first. And by lien here, we are saying I have the right to capture the goods wherever they are. I hold on to the goods rather, wherever they are. So the right of lien means that if I still have the goods and I've not sent them to you, I keep them. So an unpaid seller has a right to retain the goods for the price as they are in my possession. I can refuse to deliver them until I am paid fully. That is the right of lien, the right to hold on to the goods until I am fully paid. This right, let's look at the next slide. This right of lien happens when the goods have been sold without credit. In other words, they've not been sold on credit. In other words, they were sold on cash. And then, if it was sold on credit, the credit term has expired. You were supposed to pay by today and you've not paid. Or when the buyer becomes insolvent, you're no longer you, the buyer, able to pay your bills, and it's clear you're never ever going to pay me. This gives me in law the right to hold on to the goods. And this right of lien can only apply as long as the goods are still in my possession. In other words, it's only a remedy available when the goods are still in my possession. But as long as the goods have already left my possession, I cannot have this right of lien. So when the seller delivers the goods to a carrier, if I deliver these goods to someone else or to you, when the goods are no longer in my possession, I don't have any more right of lien. The right of lien terminates. Or when the goods are given to you, the buyer, or to your agent, or when the buyer chooses to exercise, when the seller, should be here number 3, when the seller waives his right to exercise the lien, it should be the seller, not buyer. When I waive my right to exercise the right of lien, then I don't have any more right to hold on to the goods. So the right of lien is one of the rights or remedies in law of an aggrieved seller where I have delivered goods and have not been paid. The law says that I can hold on to those goods as long as they're still in my possession and I have not waived the right to hold on to these goods. That's the right of lien. The right to stop in transit this applies where the goods have been set off. Maybe the agent is taking them or they've been delivered to a carrier. The law says that I have the right to stop them and they bring them back to me. So I have the right in law to stop them in transit. Maybe you've sent the goods to another country and they are en route to that country and they've not paid you. The law says you can command the carrier to stop them and bring them back. And so that we are saying here that where the buyer of the goods is insolvent, that is you who's buying them, you can no longer pay, and it is declared that you're insolvent, you can't pay, or they are still in transit, or payment of price has not been received. You know, you've not yet paid me. I can stop those goods in transit. And what is the duration of the transit? We're saying goods here are in transit from the time when they are delivered to a carrier, either by land, water, or air, or any other form, and they are en route to the buyer, then they are deemed to be in transit. So this is the second remedy I have in law. The first remedy was the right to hold on to the goods, the right of lien. The second remedy is to stop the goods if they are in transit. In other words, they've left my possession, they are coming to you, the buyer, I can stop them halfway. The third remedy is I have a right to resell the goods. I can choose to sell them to someone else, and especially for goods that are perishable, you know, and we did not waive this right to resell in the contract. In other words, the right still exists for me. And then here number 3, we are saying in exercise of the right of lien or stoppage in transit, I give notice of my intention to resell and the price has not been paid, I can resell them. In other words, I've held on to the goods, they are with me as a right of lien, or if not, I've stopped them in transit. When I get them back, what do I do? The law says I'm entitled to resell them to a third party to recover my money. So those are the 3 main rights or remedies available in law when you're pursuing the goods for a seller. Now let us look at the rights that are available in law when you're pursuing the actual buyer. So these are an unpaid seller's rights against the buyer. So the buyer can be sued by the seller. The seller is entitled to sue the buyer for the price of the goods. In other words, you sue them to pay you their money. or you can sue them also for damages that they have not paid you, so they have inconvenienced you this much. They should also give you compensation for that inconvenience or damages. So you can choose to sue for price of the goods. In addition, you can sue for damages, especially if the buyer refused to accept delivery or they refuse to pay for the goods. You can sue for both or one or the other. So we'll now talk about the rights of the buyer. In other words, you, the buyer, you have paid your money for me to send the car to you, the seller, and I have not sent the car. You've not received the car. What remedies in law do you have? So one of the remedies is you sue for non-delivery. In other words, you're suing for damages because I didn't deliver the car. And the amount of the damages is the difference between the price of the car and the market or current price at the time the goods ought to have been delivered. That is a price, that is the damages you get, the compensation of sorts that you get for my non-delivery. But then you're also entitled to sue for recovery of the price. In other words, you had already sent me the money for the car, but the car has not come. You can ask court that you cover your actual money that you had sent me. Or you can even ask court for specific performance. In other words, the court forces me to deliver the car that you wanted, in the specs that you wanted it to be. So you can sue for either specific performance, or you can sue to recover your money and get also some damages, or you can sue for specific performance and damages, for non-delivery. So all these are remedies available to you, the buyer, in event that neither seller I default on supplying what I agreed to supply. So I hope this video is a bit clear. Should you have any questions, do not hesitate to reach me through your class representative, or do not hesitate to send me an email. You have my email address. I'll be very glad to answer, or to comment even on this video. I'll be glad to answer whatever you want me to answer.